Good morning. My name is Jennifer Conklin, and I am a staff attorney at Elder Law and Advocacy, and I will be presenting today's topic on mold and water damage. First, I'll start with some background about Elder Law and Advocacy and our programs. ELA is a nonprofit organization. We have offices in Claremont and El Centro. Seniors need to be at least 60 years old to be eligible for our services. We provide free and low-cost civil legal services, Medicare and Medi-Cal related counseling and advocacy, referrals to community senior service providers, and community education. This presentation is put on as part of our Elder Tenant Assistance Project. As part of our Elder Tenant Assistance Project program, we provide legal services to at-risk seniors to assist clients with landlord-tenant issues prior to litigation. I specifically provide legal assistance to clients with significant habitability issues. And as I mentioned, today we are going to discuss the California Health and Safety Code and housing habitability regulations related to mold and water damage. Providing this legal information does not form an attorney-client relationship. The information presented today does not constitute legal advice. We always suggest that you consult with an attorney for advice regarding your specific situation. Overview of the law. We will be discussing the California Health and Safety Code, sections 17920 through 17920.3 and section 26147. And we'll also be discussing California Civil Code, sections 1940 through 1954. So first we'll start off with discussing landlord responsibilities in a landlord-tenant relationship. The landlord must provide a habitable unit at the time of the lease agreement. Habitable means the unit is fit for occupation and that it substantially complies with state and local building and health codes that materially affect tenants' health and safety. All residential leases and rental agreements contain what's called an implied warranty of habitability. Under the implied warranty of habitability, the landlord is legally responsible for repairing conditions that seriously affect the rental unit's habitability. It's the landlord's responsibility to oversee all necessary repairs, except if the tenant is in violation of his or her obligations as a tenant. So what are the tenant responsibilities? The tenant has a duty to inform the landlord of repairs needs. The tenant is responsible for upkeep of the unit. So the tenant must not have caused the problem. The tenant must maintain the property so that it's clean and sanitary. The tenant must allow maintenance and repair personnel to access the property. The landlord has no obligation to repair when the tenant's actions substantially cause the condition. Habitability, mold, and water damage. SB 655, which was effective January 1st, 2016, modified the health and safety code, adding requirements specific to mold. SB 655 applies to hotels, motels, apartment houses, and dwellings, regardless of date or construction. The presence of mold conditions in the rental unit that affects the livability of the unit or the health and safety of tenants can make a unit uninhabitable. Visible mold growth, as determined by a health officer or code enforcement officer, other than surface mildew, may be considered a substandard condition. And SB 655 imposes certain repair requirements on the landlord, except when the landlord has no notice of the mold problem, and when the tenant fails to keep the property clean and sanitary, or the tenant's own improper use of the plumbing fixtures contributed substantially to the mold problem. It's also important to note that even if the tenant did contribute to the mold problem, it is still recommended that the landlord repair the problems under the statutory requirement that a landlord has the duty to maintain the habitability of the residential property, because failure for a landlord to do so provides the tenant with various legal remedies. And we will discuss those remedies later in the presentation. Criteria for determining a unit is uninhabitable due to mold. Technically, there is no specific criteria. SB 655 provides a property is substandard based on mold when there is visible mold growth, as determined by a health officer or code enforcement officer, to such extent that it endangers the health and safety of the occupants. The amount of visible mold growth and the declaration of substandard are within the discretion of the officer reviewing the premises. So there are no specific quantities of mold stated in the statutes which would render a unit uninhabitable. However, the law does specifically exclude the presence of minor mold found on surfaces that can accumulate from moisture. Causes of building dampness that can allow mold to grow. Indoor sources include leaking or bust water pipes under sinks or inside walls. If there's not enough ventilation to the outside by open windows or exhaust fans in places where water is used or moisture is produced. Some of these places would be bathrooms, laundry areas, kitchens, and places where there are water heaters. And indoor sources can also come from condensation on surfaces, including windows. Outdoor sources include water coming in through leaky roofs or poorly sealed windows, or from flooding. Damp, exposed dirt in crawl spaces, or outdoor surfaces that slope or drain water toward a building, including from a downspout. Signs of dampness or mold. If there's visible mold on walls or ceilings, behind furniture or appliances, under carpets, or even hidden in areas not seen in the occupied areas of homes. If there's a mold odor, It's usually noticed as an earthy, musty, or moldy smell. If there's visible water damage, such as water stains or discoloration on walls or ceilings, peeling or bubbled paint, warped floors, or rotting wood, or if there's just damp or moist materials, such as condensation on windows or walls. Any one of these signs indicates increased risk to health, and the more that any of them are present, the greater the risk of health problems. Tests that identify the types of molds or the amounts of mold in buildings are not really useful in telling us about health risks. This is why it's not recommended to test for mold, such as measuring the mold spores in the air. Health problems from damp or moldy buildings. Someone can experience asthma attacks. Even people who already have asthma can experience asthma attacks. Someone can have a new asthma diagnosis. Respiratory infections such as bronchitis. Breathing symptoms such as hay fever, sneezing, stuffy nose, sore throat, wheezing, breathing difficulty, or a cough. Eczema or skin rash. And it's important to note that mold can affect people differently depending on how sensitive they are and how much they are exposed to the mold. The California Department of Public Health recommends addressing water damage, dampness, visible mold, and mold odor by identifying and correcting the source of water that allows the microbial growth or contributes to other problems, the rapid drying or removal of damp materials, and the cleaning or removal of mold and moldy materials as rapidly and safely as possible. If a moldy area is bleached, cleaned, or painted over without fixing the source of the dampness, the mold is likely to grow back again. Toxic mold written disclosure requirement. Residential landlords must provide written disclosure to prospective and current tenants of units affected by mold when the landlord knows or has reason to believe that mold, both visible and hidden, is present that affects the unit or the building, and the mold either exceeds the permissible exposure limits to molds under the California Health and Safety Code, or poses a health threat according to the guidelines developed under the California Health and Safety Code. To date, the state of California has not published any permissible exposure limits for mold in the indoor environment. Based on the published Environmental Protection Agency guidelines, indoor mold spores should be similar to those in the outdoor environment. Guidelines simply state dampness, water intrusion, or fungal growth should always be eliminated in a safe and efficient manner. So the residential landlord is not required to conduct air or surface tests of units or buildings to determine whether presence of mold exceeds permissible limits. And the landlord does not have to provide written disclosure to prospective tenants of a dwelling if mold was remediated in accordance with the California Health and Safety Code, section 26-130. So if you have notified the landlord of a needed repair for mold, the landlord has to give notice to enter before the repair. A landlord may enter a unit to make necessary repairs and improvements and may make an agreement to enter either orally or written. If it's an oral agreement, the agreement must include the date and approximate time of entry. The entry will be within 1 week of the oral agreement. If there's an oral agreement for the landlord to enter, a landlord is not required to provide written notice of entry to the tenant. If there is written notice of landlord's entry, then the written notice must include date, approximate time, and purpose of entry. The notice may be either left or mailed. If the notice is left, it may be left with someone of suitable age and discretion at the premises, or left on, near, or under the usual entry door of the premises in a manner in which a reasonable person would discover the notice. 24-hour notice is typically considered reasonable. If the notice is mailed, mailing at least 6 days prior to entry is typically considered reasonable. Notice of entry from the landlord is not required when the tenant is present and consents to entry at the time of entry. So now I'm going to discuss the steps to take if a repair is needed at your unit. First, you want to determine that the tenant did not cause the problem. Then you want to notify the landlord in writing of the needed repair. You'll want to consider certifying the letter and keep a copy for your records. You'll want to take pictures of the unit conditions. And then lastly, you'll wait a reasonable time or 30 days. 30 days is typically considered reasonable unless faster repair is necessary for the health and safety of the tenant. Remedies after notice to landlord with no repair. So now we're going to discuss the tenant remedies and the risks associated with each. You can call the city or county building inspector or health department. However, the risk is if the mold is a very serious problem, the unit may be condemned and you would have to find alternate living accommodations. You can repair and deduct. So pay the cost of repair and then deduct that amount from your rent, but the risk is you'll be served a 3-day notice to pay or quit. You can withhold rent. This should be used only for very serious defects, and again, could result in being served with a 3-day notice to pay or quit. You can move out and abandon the property. However, this could result in the landlord filing a small claims lawsuit for breach of the contract. Lastly, you could try to sue your landlord in small claims court. And I'm going to go through each of these remedies in a little bit more detail. So the repair and deduct remedy. Again, you want to first determine that the tenant did not cause the problem, and you want to notify the landlord in writing of the needed repair. You want to consider certifying your letter and keep a copy for your records. You'll want to take pictures of the unit conditions. Wait a reasonable time or 30 days unless faster repair is necessary for the health and safety of the tenant. Determine if mold is a serious threat to the health and safety of the tenant. The cost of repair must be less than or equal to 1 month's rent. And also note that the tenant cannot use the repair and deduct remedy more than twice in a period of 12 months. Steps for withholding rent. Determine that the tenant did not cause the problem. Notify the landlord in writing of the needed repair, and consider certifying the letter and keeping a copy for your records. Take pictures of unit conditions, and wait a reasonable time or 30 days unless faster repair is necessary for the health and safety of the tenant. Withholding rent should be used if a serious breach still exists of the landlord. So that would be continued presence of mold and the landlord's failure to repair. You'll want to determine what amount will be withheld. That's typically a percentage or the reasonable value of the unit affected by mold. You want to place the withheld rent in a separate bank account, and this will prove that you withheld because of the breach of implied warranty of habitability and not because you didn't have the money to pay your full rent. This would be a stronger defense if the landlord decides to file an unlawful detainer or eviction against you. And then lastly, you also want to write a letter to the landlord explaining that you're exercising your right to withhold rent. And the last remedy is move out or abandonment. Again, determine the tenant didn't cause the problem. Notify the landlord in writing of needed repair. Consider certifying the letter and keeping a copy. Take pictures of the unit conditions and wait a reasonable time or 30 days. Determine if defects are serious and related to tenants' health and safety. And then lastly, notify the landlord in writing of your intent to move out by a certain date due to the mold conditions. This concludes our presentation on tenant rights, mold, and water damage. Please feel free to contact us with any further questions that you may have.